What is the urgency in the matter?
What is there?
No, that is no. She is mentioning another matter that should be listed. Whether the other matter is listed tomorrow?
Yes, 1,152.
All right, then it will be listed. Just give the memo.
Thank you.
The only thing, if the other matter is similar, then it will be tagged and listed tomorrow.
Grateful, sir.
Okay. Yes.
May I please, Your Lordship? Lord, this is a writ petition 339 of 2017, in which a very short issue arises for consideration, namely this.
Yes.
I'll just give a brief overview, case in a nutshell, my lord, and then through the date sheet, I'll place the documents for my lord's kind consideration. My lord, under section 5(1).
Now, are you very serious about the challenge against the Rule 8 of the MCR of 2016?
That's I said. It's very short. Now I'm going to show you it's a single point only.
All
so
right.
Your Lordship I will distill it down to a single point, which is this, my lord.
All right.
That I have a right, a crystallized vested right, which flows from, my lord, an approval granted by the central government under section 5(1) of the MMDR Act. The state had a corresponding obligation, and the one-line prayer which I'll have for my lord's kind consideration is, if we are right in our submission, then we are only seeking a direction which is in the nature of a ministerial act or a formality to actually execute the mining lease. So it is going to be as simple and short as that. Now, my lord, may I just put it into context for my lord's kind consideration? My lord, pursuant to a recommendation which a state government made sometime in 2020, the central government, my lord, my lord, this is just opening. Don't trouble yourself. Rest from the date sheet I will show. I'll just put the whole case in context so it will become easy for my lord's consideration. My lord, after the state government had made a recommendation, my lord, in 2020, the central government, my lord, under 5(1) issued what is called a grant order.
Okay.
The grant order, my lord, said that the state government has to do A, B, and C, and we had to get an environmental clearance and a forest clearance. Lord, your lordship will take it from me that the environmental clearance and the forest clearance have been obtained. There is no dispute. State government issued a communication, my lord. At the moment, I'm styling it as a communication for simplicity. It had certain terms and conditions which we had to accept. And I will show, my lord, we accepted that as well. My lord, the state government had put certain terms and conditions which they said required approval of the central government under Rule 27(3). The central government on 2 occasions came to reject that. So as far as we were concerned, my lord, it said, do you accept these terms and conditions? We accepted those terms and conditions. Certain terms and conditions, bracket the bone of contention, as you would see, expressly the state government said, this is subject to the central government approval under 27(3). I will show the 2 letters how the central government said no permission required. So, my lord, in one line, there is a grant, there is terms and conditions, bracket LOI or whatever it is called. I accepted it. And the other terms and conditions, my lord, the central government refused to give. So it became a crystallized, accrued, and vested right which inured in my favor. So all that was required, my lord, was that the state government had to formality issued the deed itself, but my right stands crystallized, which is why I said the first level of my submission will be based on my right and the corresponding obligation which they had.
I think you should put this this way, that you have satisfied the requirement substantively, only the state government has to act upon this part.
I am so grateful, Mr.
No right, we cannot accept that contention that a right has been crystallized in your favor. The right, because it's still a process, still some process is there You can say this I have done.
All right. For the sake, may I
Yes.
develop it? I just was giving
Yes.
an overview. May I put it like this, Manoj? That there was a central government approval and the terms and conditions. So, Manoj, they had to execute this is the first layer. All compliances, Manoj, which were required to be done by me, had all been done. The last of which was on 2nd January 2017, which Manoj, the NPV was also deposited. So that aspect was also done. I'll take my lot through all the permissions and clearances.
All right.
In that sense, Manoj, this grant was brackets open operationalized. Now, my lord, this act called the MMDR Act, my lord, this came to be amended. In the amendment, my lord, there is section 10. Section 10, my lord, is in two parts, which I will place for my lord's kind consideration. Bringing in a new regime, my lord, in the direction of transparency and auction. And equally, my lord, it had a second part. And in that second part, my lord, they saved cases in 3 categories. The third category in which I believe we fall are cases where the central government had issued a grant or approval. So expressly by legislative intent and policy, while making a change in the regime, they had, my lord, a saving provision, if I may call it. And that saving provision had 3 categories, and I fall in one of those categories, namely category 3.
What are those categories?
Yes, I'm going to place all.
All right.
And a judgment of the Supreme Court, my lord, in the Bhushan case, also notices these 3 categories and passes an order in line with the legislative intent.
Yes.
So I'm going to place all that. Just let me give you the whole flavor so that in a nutshell, my lord. So, my lord, with great respect and humility, I say, you will hear an argument to say that there's been a change. It should all be taken in the direction of an auction. But as I said, Parliament itself was careful in balancing rights. And that's where when I show the judgment, my lords will see how rights had accrued which have been saved. That has also come up for consideration in several judgments, my lord, of the High Courts. Rajasthan High Court, single judge and division bench, my lord. Guwahati High Court, Karnataka. And in most cases, my lord, exactly the relief which I'm placing for my lord's kind consideration of execution of a mining lease has been done. So that's one. The second limb, my lord, of the argument which will come is, look, those terms and conditions have not been fulfilled. And if the terms and conditions have not been fulfilled, even if you are eligible and safe, you are out. To which, as I said, first line answer, your own communication said it is subject to approval of central government under Rule 27.3. Central government not on one occasion, but on 2 occasions, my lord, says no, I'm not giving my permission. And all other compliances which I had to do, as I indicated, my lord, whether it is mining plan, FC, EC, deposit of NPV, all of that has been done by me. So according to me, it is, my lord, a fig leaf of an argument, imaginative argument. It doesn't exist in reality. It is only in an attempt to non-suit to defeat what my lord rightly put it to me is a position which had been crystallized by virtue of the grant order. So that also, my lord, with great respect and humility, does not come into play. Now, my lord, kindly see that what is the object and purpose. We have a sponge iron plant, one of the oldest in the state. 487 crores of investment have been made. It generates employment. We want to further expand it. What is the first thing that a business needs when it expands is certainty. And what is that certainty? Raw material certainty. That is exactly why, my lord, this order or this relief that we are seeking is vital for that larger purpose. In case it happens, my lord, it is a win-win situation for all stakeholders because you're going to put larger investment, expand capacity, generate employment, and the state will be the beneficiary of royalties, levies, etc. So in that sense, with great respect, my lord, on facts, it would be a win-win in the larger interest. Everyone benefits subject to my satisfying the court that the relief that I'm seeking. So, my lord, that really is the line of argument that my lords will hear as far as they are concerned. Then my lord asked me about ruling. That also came to be omitted. That's gone. And lastly, as my lords would recollect, the 9/12/22 Supreme Court order has cleared all decks to say this writ petition can be heard and decided. There is no fetter, notwithstanding any other case.
Nine,
and the
9,
court
12,
can
9,
decide this.
19-2 or 9-12.
9th December 22, the Supreme Court order, pursuant to which we are back before the court, which my lord said this case can be heard. Other matters may be pending, but this case can be heard and decided by this court. So that is also, my lord, no impediment which stands in the way. Now, my lord, having said this, if I may request my lords to kindly have the date sheet which we have filed on 20th of July, along with, my lord, the writ petition paper book. My lord, it's like this. It says date sheet. It's like a list of dates.
Just a minute. This is with the written submission that you have placed the dates.
Yes, my lord. Along with the date chart.
All right. Yes, with the written submission, it is there. Okay. It was filed on 20th of July.
Yes, my lord, 20th.
All right.
Written permission 17. Below that.
My lords have the date chart.
Yes.
Yes. So, my lord, with my lord's permission, I'll just use this for flow and continuity and context. 23rd August 91, the state government issued a notification under Rule 59 calling for applications for grant of a mining lease for iron ore over 466 hectares in Keonjhar district.
Yes.
Lord, I believe we are on the same page in terms of the date sheet.
We are looking at the chronology of events. That would be better
Yes.
for us.
Yes.
It is there. You just refer to from that only.
Yes, I'm reading from this.
All right.
My lord, I was on serial number 1, 23rd August 91.
Yeah.
And that is the date, my lord, where the application, the state government by notification sought applications. My lord, on 29/10/91, the petitioner applied for grant of a mining lease for this area. Now, my lord, this second is important. 2/2/2000, pursuant to an application for mining lease, the state of Odisha recommended to the central government grant of a mining lease to the petitioner for an iron ore of 459 hectares and requested for the prior approval of the central government under section 5(1) of the MMDR Act and the subsequent letter of 16th May 2002. Now comes, my lord, the most crucial date as far as I'm concerned. 17th July 2002,
Yes.
the central government granted prior approval under section 5(1) of the MMDR Act in favor of the petitioner. If my lords could kindly have page 45 of the paper book.
Yes. Annexure 2.
May I, my lord, please page 45?
I think it is Annexure 2. Annexure 2 to the writ petition.
Yes, ma'am. My lord,
Yes.
kindly note the date, 17 July 2002. The subject, grant of a mining lease for iron ore over an area of 459 hectares. I am directed to refer to your letter dated 16th May 2002 on the above mentioned subject, and that, my lord, is grant of mining lease, and to convey the approval of the central government under section 5(1) of the MMDR Act to grant of a mining lease for an iron ore area of 459 hectares in district Keonjhar in favor of the petitioner for a period of 20 years. Lord, I just pause for a minute. The key words are convey approval of the central government under 5.1. So this is like a grant under 5.1 by the central government in my favor. Now please see clause 2. Before allowing grant of mining lease, the state government may ensure compliance of the provisions of the Act and the rule and other applicable acts and rules, including Forest Conservation Act and environmental notification as issued and amended by the Ministry of Environment and Forest. If my lord could kindly do me the favor of just noting two things here for convenience, my lord. 16507 is the EC, the date of the EC. Just if my lord could just make a note here, it may just be convenient. It's in my list of dates also.
No.
And 20th December 2016 is the FC. Then, my lord, see the third part. A copy of the order passed by the state government may be furnished to this department for record. Now, my lord, if my lord has the date sheet, my lord should
Not just
see-
straight come to the state government. What the state government has done after this.
Yes, I'm exactly
communication.
coming. Serial number 4, my lord, in the date sheet, 27/9/2004. May I read with my lord's permission?
Yes, you're going
The
back.
state government addressed a letter to the petitioner. Lord, I'm on the date sheet, madam.
Here.
May I, with your permission, place serial number 4 on
Yes.
the first page?
Mhm.
27/9/2004. The state of Odisha addressed a letter to the petitioner imposing.
That is 5, not 4. That is serial number 5, not 4.
Lord, I'm reading from the
Actually,
date
your
chart.
lordship must be looking at the written note of submission.
Ah.
So we are referring to the date chart.
Oh, we are referring
Date
to-
chart is also given, my lord, on 20th July.
the date chart is not scanned.
There is one date chart is available, my lord.
Lord, I can equally do it from that. There's no difficulty.
All right.
Sorry.
4, yes, I got
Lord,
it.
it's so important to be on the same page, brackets literally. So today we are now fortunately on the same page, literally. Lord, the serial number 4 on the first page. Lord, both are mirror images. It's
Yes.
just that it's a separate document.
Yes.
No, I think your latest date chart has some dates missing. That is why the confusion. Few dates.
Lord, your lordships always have a keener eye than we have. I'm grateful for.
All right.
27/9/2004. The state of Odisha addressed a letter to the petitioner imposing certain conditions to undertake expansion of its sponge iron unit, which was to be fulfilled prior to the execution of the mining lease. The state government accepted that imposition of conditions 12 to 17 was subject to approval of the central government in terms of Rule 27.3 of the Mineral Concession Rules. If my lords could now kindly have page 52, which is this communication.
27/9.
Sorry, ma'am.
You are taking us to the communication 27/9.
Yes, ma'am.
Yes.
Page 52.
52, yes. I
Annexure
got
4.
it.
No, this is just in line of the opening submission which I made. Okay. My lord has page 52. Please see, my lord. Application filed by the petitioner for mining lease of an area of 466 hectares. I am directed to inquire whether you accept the following terms and condition. And kindly note this, my lord,
Yes.
which would govern the grant of mining lease in respect of your application. Your reply as per the enclosed proforma should reach the government on or before 25/10/2004, failing which it will be considered that you do not accept the condition. So, i.e., accept these terms and conditions, and if you give your acceptance, then my lord,
There are two
that
sets of terms and condition, Mr. Join. That first is the terms and condition in the model form.
yes,
They generally refer to that.
Absolutely.
And additional terms and conditions has been formulated in this letter.
I am grateful. Absolutely, my lord. I'm just first saying on the first para. Now, my lords are right. These standard conditions are all stated here, subject to terms and conditions. I'm not troubling my lords. For a minute, my lords will just note at 53 bottom, condition number 12 to
12.
page 55, condition number 17. Just mark it for a minute, my lord. I'll come back to it in a minute.
Condition number?
My lord, 12 at the bottom of page 53
Yes.
to 17, which goes from page 54 to 55. If my lord could just turn to 55 for a minute. And now see, my lord, at page 55, clause 2. What my lord put to me.
Clause?
Clause 2, full 2. Paragraph 2.
The condition stipulated?
Yes, the conditions stipulated in para 12 to 17, right, my lord, which I just showed from 53 bottom to 55, are subject to approval of the Government of India under Rule 27(3) of the MC rule. So they themselves say, my lord, this is subject to the approval of the central government. Now kindly turn to page 56 for a minute. This is 5th October 2004. This is my letter accepting, my acceptance.
07, page 58?
Yes, my lord. Page 56.
56.
Yes, my lord. 5th October 2004.
There is annexure 5.
My lord, annexure 5.
Yes.
My lord, kindly see your letter of 27(9), which is what I placed for my lord's consideration at 52. Please find enclosed duly filled form acceptance of the terms and conditions offered by the state of Orissa in your letter in connection with the grant of the mining lease over an area of 459 hectares in Kionjhar district. My lord should recollect at 52, they said whether you
What is that
accept-
form that you have enclosed with that letter? Because this is not a straightway the acceptance. You said whatever the acceptance I have recorded in the form. What is that form?
No, my lord, kindly just see.
Just please find
Yes,
enclosed a duly
duly
filled
filled
in
form
form of
acceptance.
acceptance of the terms and
Yes, yes.
condition.
Correct,
This
my lord.
itself is not a communication of
Yes,
acceptance.
my lord. Kindly have the next page, my lord.
Next page.
Yes.
This is also
57.
not a form.
My lord, 57. Form of acceptance of the terms and conditions offered by the state. And so he formally says,
All right.
I so-and-so managing director and duly authorized person to communicate acceptance and accept all terms and conditions. I will also abide by terms and conditions laid down and as may be amended under the act.
All right.
Right, my lord? So I'm just going step by step. What the state wanted at page 52, my lord sees at 56, 57. Now coming to para 2 of the state government's letter, the answer now is annexure 6, page 58, which, my lord, is the central government, serial number 5 of the date sheet, 4th July 2005. Annexure 6, page 58.
Yes.
They write, my lord, with respect to that, saying, subject imposition of conditions by the state of Orissa under Rule 27(3) of the MCR for grant of mining lease in favor of the petitioner, I am directed to refer to your letter of the above subject to say that the proposal for imposition of the special condition of Rule 27(3) has not been agreed to. The proposal is returned in original. So if my lord,
How do you just explain this situation now? It's a glitch between the two entities, state and the union. They are not agreeing on the same terms and condition.
correct,
They wanted to expand these conditions. Central government did not agree to that.
correct, union didn't agree. So that para 2 said you have to go to the union. That's my lord the scheme of the rules. Union doesn't give it. So as far as those rules are 12 to 17 are concerned, at the bottom of page 53 to 55, that the central government, my lord, said no. And there is going to be a second no as well as we move on. Now, if my lords could kindly come back to serial number 6 at page 2 of my deed sheet. Yes, correct. So, my lord, the statutory scheme requires, and they therefore rightly said that the central government has to under 27(3), it was declined. Now, please see serial number 6
Serial
of the
number?
date sheet at page 2. May I place it, my lord?
There is another request to the central government.
Once again, the state government requested the central government to reconsider its decision. However, the same was rejected on 8/12/2005, stating that, and I'll just show the document. Now, my lord, please have the rule itself, because that will, my lord, be a complete answer to what my lord put to me. My lord, Rule 27A of the Mineral Concession Rules.
All right.
May I just read it? It's just 3 lines. The state government may, either with the previous approval of the central government or at the instance of the central government, impose such further conditions as may be necessary in the interest of mineral development.
You are reading from page?
My lord, this is from the rules itself.
No, what is the reading?
MC rules?
27.
1960. Yes,
Rules, Philip.
27.3.
Rules.
Thank you. I would have thrown.
Lord, your lordship, I take it from it standard vanilla. It simply says with the previous
Then I said,
approval
I
of the
would-
central government, which
You
is
got it.
exactly what the state put in para 2.
What is the full name of the rules?
My lord, Mineral Concession Rules 1960. This is after the act in the same book, my lord. If it's universal.
Okay, we are now getting here. In this book, it is not there.
No, there's another book with those.
This is a conservation and development rules.
My lord, Mineral Concession Rules
Concession.
MCR.
1960.
Quite for the con- It's here. Sit down.
2002.
Same thing. That and this is the same thing.
Courtmaster.
TJ
Courtmaster.
kind of-
Courtmaster.
I can get-
We start from page 37 onwards.
Sorry.
May I?
State government may. This is the
Yes.
state government may.
Yes. The state government may, either with the previous approval of the central government or at the instance of the central government, impose such further conditions as may be necessary in the interest of mineral development. Which is why, my lord, the state government in its paragraph 2 said you have to go to central government. First 4705 I've shown, my lord, central government. Now, my lord, kindly have page 59 of the paper book.
Page 29 of the writ petition.
Yes, ma'am.
Your grounds? Your grounds?
No, I'm reading now the second letter, my lord, how the central government at page 59,
59.
annexure 7.
Yes.
It's 17905, my lord, relates to serial number 6 of the date sheet. Now, my lord, kindly see 17905. Please come to page 60, last para. 60.
Yes.
It is therefore requested once again that the proposal of the state for imposition of special condition submitted to the government of India by this department and returned back by the government of India by the letter be reconsidered and approval for imposition of special conditions be communicated to this department early. So if I may call it, my lord, second request. Now please have the response at page 61, which is 8th December 2005.
Para 2.
Yes. The state government has proposed to impose the conditions in order to ensure that iron ore reserves of the state is gainfully utilized for maximum value addition inside the state. The central government is, however, of the view that mining is an independent activity and any downstream industry is a commercial decision of the lessee. As such, the central government is not in favor of imposing the conditions proposed by the state in this case. Right, Manoj? So as far as 27(3) conditions are concerned, from 12 to 17 in the 27(9) letter of the state government, the central government, as required under the statute, Manoj, does not give them the permission and the approval. May I, Manoj?
Just
Sorry.
This color is not really this color 14 of the it is a separate issue.
Just to complete my point on the 5(1) and what flows from it, if my lord could have page 108.
108.
My lord has 108.
Just
My lord, this is 16th May 2007.
Sixteenth May.
16th May 2007, my
Yes,
lord.
yes, got it.
Yes, your lordship may only note, this is my EC. Kindly just mark there EC, environmental clearance. And please have page 74 now. Annex to 11.
No, just tell us in a straight way that whether there is an issue relating to the environment clearance.
No, man.
Don't go to these pages.
No, no.
Issue is the only.
I'm downtaling it into the 5(1) approval, which I showed my lord, the grant. No, my argument is-
there is no dispute about it. So far, I understand.
Yes, I'm showing my grant is fully crystallized and operationalized. That's the short point. So I just had to show three things. Grant order I've shown. It said EC, FC. I'm showing you the EC and FC. It said state government letter, which is, my lord, in the nature of terms and conditions akin to a LOI. And 27(3) central government has not done it. That closes, as far as I'm concerned, everything was ready for them to execute.
No,
the
I
matter.
have a questions to you.
Please, ma'am.
This the conditions which is now under dispute. It appears for your acceptance letter, you have also accepted those conditions.
No, my lord, with great respect, I'm saying they are.
No, that this required approval from the central government is the one aspect of the matter.
Yes, my lord.
But while communicating the acceptance, you have the wholesome acceptance you have communicated to the state government.
Yes, my lord.
That I accept also
Yes,
this condition.
all the conditions which I had to fulfill, I have fulfilled. 12 to 17, their own
And the
communication.
central government decision is very transparent. They
Yes.
said that this is not an issue that will be decided by the central government.
ma'am.
Let the industry decide whether there will be this downstream
Yes.
industry, they will within Orissa or not. This
Yes.
is a matter of commercial decision.
Yes, ma'am. Correct.
But what I am referring to that you have accepted this condition also, though it requires under Rule 27 of the approval of the central government.
I accepted it as it
two aspects, Mr. John, just try to
Yes,
understand
please,
that.
please. Of course. we are
You-
engaged.
But we find it from the acceptance that you have no difficulty in accepting that condition. Though central government say, no, we will not give any approval because this doesn't come within our domain.
Please.
It is a commercial decision has been
Yes.
taken.
Yes. May I answer it straight away? That communication of 27/9 stated, as I showed, my lord, do you accept? I accepted, my lord saw the proposal. That very letter in para 2 had said certain conditions are subject to approval and permission by the central government under 27(3). Central government has not
No,
given.
my issue is there also.
Just give me half a
State,
second.
state government has laid down. State government did not say that can be the two processes that I can visualize. State government first proposal that you want to add this condition, send the communications to the central government, and subject to the approval or disapproval, whatever, they will take a decision and let it be communicated to you. They have not followed that process. What they have followed, they have transparently made, this is the condition we going to impose. However, this within not our domain, 27, the central government will decide it. But the conditions were made known to you.
Yes, my lord.
There is one aspect, Mr. Jain, just hold for a moment.
Yes.
And you said, we agree. These conditions also, this is number one to look into the matter. Then the central government say, then let it be decided by the industry concerned. There is a petitioner. It is not within our domain that you can they accord the approval or not.
No, with great respect, may I respond?
No, now I think this is the position that emerges for your acceptance.
No. Central government says, I am not giving it because this is a commercial decision, but they reject. But the key thing is, if I ask,
No, they
and
have
somebody
clearly
rejects,
stated why you are rejecting.
central government is rejected.
They say why you are rejecting,
Yes.
because this doesn't fall within our
Yes,
domain. It is a
absolutely.
purely a matter of commercial decision.
Absolutely correct, my lord.
Right.
Therefore, short point for my lord. Two answers. My lord. First answer, in law, central government has the power when it comes to special conditions to accept or reject, or accept or deny, which they've denied not once but twice. That's one part. The reason they say is that this is not in the remit of center state. This is in the commercial decision of the grantee or the proposed mining leaseholder whose application has been made, right? Every condition in that state government letter, EC, FC, mining plan, consent to operate, NPV, all which is in my hand and purview, I have already done. Right, my lord?
There is no confusion
Correct.
and there is no conundrum.
Absolutely.
The things are very transparent.
Yes.
What you
absolutely.
have accepted, just I'm to pointing out,
Yes.
that you also accept this as subject to the approval by the central government.
Yes.
Suppose for any reason central government says, since the state government has proposed the condition, we approve. You
Yeah.
have no objection,
Yes, my lord.
right?
Has to be correct.
So the decision so far starting in the downstream industry out of these iron ores that will from the mines you will just extract, that you have no problem that this set up a downstream industry from the iron ore within the state of Orissa.
Correct, my lord.
Is it a commercial decision or not?
Yes, that is a commercial decision. My lords are absolutely right.
Yes.
So, my lord, exactly what I was coming to. There were two possible scenarios. Central government could have said yes. Central
Let
government
us
could have
also
said no.
understand, Mr. Join, why you are not resiling from this earlier acceptance. It is a sort of resiling from the earlier acceptance. Because how and what way the central government will decide, over that you did not have any control at the point of
Yes.
time when you have accepted it,
Correct.
right?
Yes,
And
my-
number two is that you have is an omnibus acceptance you have communicated to the state government.
yes. My lord, kindly just come back to page 56 and
Yes.
57. I'll be grateful.
Page 56 and 57.
Yes.
This is the okay. Those.
May we come back to that document? my lord?
All right. Yes.
Yes. Correct. Yes, sir.
Just see, that is why I'm referring to.
Yes, but I'm also trying to assist my lord. So I'm going back to the document because that will make the position clear. My lord, on 4th and 5th October 2004 at page 56, I write saying, please find the duly filled in form of acceptance, as my lord put it, the standard format,
Right.
acceptance of the terms and conditions offered by the state government in its letter mentioned above, which is 27(9.
Yes.
With the grant of mining lease. Now, kindly let's turn over the page, my lord. form of acceptance of the terms and conditions offered by the state in their letter, subject to which mining lease is proposed to be granted. Now, kindly see this. I, the managing director of the petitioner and the legally authorized person to communicate the acceptance on behalf of the company, do accept all the terms and conditions laid down by the state of Orissa in its letter dated 27/9/2004. That means as 27/9/2004 stands, exactly as my lord put it,
Yes.
which came with para 2.
Yes.
The moment the central government, in my respectful submission, my lord, under 27(3) declines that, then 12 to 17 are no longer valid or in play, they become
No,
inoperative.
my point is not here. My point is there, the language that you have issued, it doesn't say that your condition number 12 and another condition that you have mentioned in paragraph 2 will be subject to acceptance if the central,
No, no, I'm
on the basis of the
no,
decision of the central government.
My lord, with great respect and humility, we have to look at the substance of the matter. I have sent in the form of acceptance, which is a format saying as per 27(9). 27(9) itself had para 2. So
Yes.
I cannot, let's put it,
All right.
just give me a minute. Let me take a scenario. Para 2.
I got your point.
Yes.
I am from a different plane. I am asking this question.
Yes, ma'am. Yes.
So according to the offer is not a complete offer because it is a conditioned offer. What will be decided by the central
No,
government?
with respect, it is not conditional, but the 27(9) said 12 to 17 are conditional upon central government
That is
approval.
what I am pointing out.
Yes,
These are the
correct.
conditional, this is a proposal subject to the approval.
Yes, my lord.
But how you have accepted it?
My lord, I have accepted it as it stands.
Okay.
As it stands. Let me.
I am getting your
No,
point, no doubt
no,
about
I'll
it.
put it. I'll put it another.
But I am asking from a different plane.
Yes.
That you did not know at that point of time that how the central government will decide that
Absolutely,
issue.
Lord. Correct.
But you have given the omnibus acceptance of the letter.
My lord, please just let's just.
No, I am asking this question. That is the subsidiary
I'm
question that I have asked you. Are you resigning from this?
I'm not
omnibus?
resigning.
All right.
I'm not resigning.
All right.
And my lord,
Then
when they
proceed.
wrote that letter, he said exactly. That's why I read it out. that
That
letter.
they can still recall.
No, there's one
paragraph
very,
three,
I'm
paragraph
very grateful because my lord put this question to me. I'm extremely grateful. Just bear with me for a minute, my lord. I'll be extremely grateful. My lord has said,
three. Yes.
I am directed to inquire whether you accept the following terms and conditions as stated. Now see the next. Your reply as per enclosed pro forma should reach the government on or before 25/10.
Yes.
So in the form in which it is
that is
prescribed,
provided. Yes.
I had to do it before a particular date, right, my lord? Which I have done. That day we didn't know, as my lord rightly put it to me, what the central government would do. But if I don't respond before 25/10 in the format, then I miss
That
the
is
bus.
well understood. That is well understood.
Now, my lord, therefore, my acceptance was to 27/9. 27/9 had para 2.
All right. We understand now. You are just this developing your argument on this para 2 of that communication.
Yes, my lord. Correct.
That cannot now anymore treated as a condition provided by the state
Because
government.
it's a statutory requirement that if you want to put special conditions, you have to knock on the doors of the central government to take the permission. In this case, they went twice. In fact, I am going to put it the other way around. Having twice knocked on the doors of the central government, not once, but twice, and appealed to them and said,
No, why?
got rejected.
No. I'm asking you. This is not a legal question. This
Yes,
is not
yes.
related to the.
Please.
Why this petitioner is not inclined to set up the industries within the state of Orissa?
We are.
Make that statement. We just observe it.
Yes.
Please this
Yes,
writ
but I
petition
think-
right now.
Absolutely. There's no dispute. I'm so sorry. I didn't.
What? Because state government
We are-
concerned that
We
the
are
industry should
committed,
come up
my
here.
lord, we are committed, and I'm so sorry. I now realize where my lord is coming from. Not for a moment.
Yes.
We are here, committed to being here. There's no
And
question
set up
about.
the downstream also.
I have
within
my
the state of
sponge.
Orissa.
I have my sponge iron plant here itself. Everything is here.
By the time he made an application, he had a subsisting plant. But what he had all promised, that was not done. This is another issue. Lord, we had about 24 applicants for an area. And his application was that I will use this ore only for the industry. That is why we had picked up his application in preference to others.
Now, Mr. Join clearly submits that.
What was that date? We are like 25 years after in point of time. And that's very interesting. I think only on that ground it should be dismissed, but let me come to the main point. What is 27.3? Rule 27.1 lays down the general conditions of lease. Rule 27.2 says special conditions. Now, Rule 27.3 says a captive condition. My lord, why a captive condition? My lord, I'm giving you a lease for 20 years. At that time, it was 20 plus 20. It was a 50 years grant. So, state said that I will give you only with a captive clause condition so that tomorrow you don't have the flexibility of selling the ore. His application for mining lease was very clear that I will only use it for my industry. The recommendation of the state government was that I am giving him in preference of others because A, these are his subsisting plants, B, these are what he has now promised to do. I will show you, Lordships, everything. There was an MOU also, expansion, etc., etc. Now, for 2 times, the government of India did not grant an approval under 27.3. Your Lordships have seen that, but subsequently there are other letters. Now, till I had a 27.3, and your Lordship rightly said, my lords, what happens is I make a recommendation, they grant approval, I give a terms and conditions.
No, Mr. Parija, try to understand that the question that I posed.
Yes, my lords.
This background fact of this fact is
Correct.
that the central government has rightly stated we will not grant because it is a matter of commercial decision, number one.
Yes.
That is why I straightway asked Mr. Join that you respond to that. Where are you ready? He says immediately says yes.
But can I just make one request? Can I just complete this? Because
all
that's
right,
something very
all right.
important.
All right,
Let
I'll
it
take my
have a start.
All right.
Now, what better way to answer my Lord's question than page 121?
Page 121.
Yes. My Lords will see at
Yes.
page 120 is the cover letter.
Right.
23/12/16 proceedings of the screening committee in the director of mines under the chairmanship of the director of mines Odisha to examine cases under 10A, 2B, 2C, etc. Now, kindly see, my lord, this is in my most humble and respectful submission, an answer to what fell from my lords. My lord, please have A at page 121. The answer is in the next page, but for continuity. Disposal of applications under 10A 2C, mineral mine lease application filed by the petitioner. Now, my lord, kindly have the bottom A, small a, right at the bottom of 121.
Yes.
As against the conditions stipulated under clause 12 of the letter of intent, the applicant has achieved partial expansion of phase 1 in respect of the existing sponge iron unit at so-and-so as given below. Please turn over the page, my lord.
Yes.
At 122, the applicant has planned for full expansion of the existing unit upon grant of the mining lease. In response to the conditions stipulated in clause 16 of the LOI, the applicant was required to establish a new steel plant at Bamra. From the compliance submitted by the applicant, it is observed that the applicant has foregone the proposal of setting up the plant at Bamra owing to scarcity of water. This fact was also brought to the notice of the government by the applicant. In response to clause 17 of the LOI, it is observed that the applicant has already made an investment of more than 50% of the project cost, that is 363. Today it is 483. Now kindly note this para. In view of the above status of compliance by the applicant and taking into consideration that the applicant has established an industry inside the state, thereby contributing to the growth of economy of the state, the committee recommends the government may issue a grant order in favor of the applicant, subject to verification of payment of NPV by the applicant, as stipulated in the approval under 2(3) of the Forest Conservation Act and guidelines issued by the MOEF, which was done on 2/1/17. My lord, with great respect and humility, this is the complete answer. I was going to come to it. This answers what fell from my lord. Apropos the condition, apropos I am in the state, and the government says we recommend the grant order subject to NPV, and NPV, my lord, will say
When have you
at
made
serial
that?
number 17 of the date sheet was paid on 2/1/2017 of nearly 29 crores.
Where, in which page you are reading?
Serial number 17, page 4 of the date sheet.
Date sheet. Okay.
Annex 14 of the paper.
That's annexure 14 of the paper book.
Straight. Annex 14, page 115.
130. Not serial number 17 at page 4 of the date sheet.
Yes.
May I, with my lord's permission? Petitioner deposited 28.96.
Yes.
My lord, can I place serial number 17, 2/1/17? Petitioner deposited the NPV amount of 28.96 crores and requested the government to execute the mining lease. And that document is at page 130. And this is after the screening committee meeting, which is 20th December 2016, which I just showed my lord at 121, which is serial number 15 of the date chart. Lord, your lordship may take it from me at 130 is the letter. If my lord could kindly have a look, page 130.
Yes.
Annexure 14. To 117 to the principal secretary. With reference to the above subject, we submit as per condition so and so. We have already deposited NPV of 28.96 crores. Copy of the receipt is attached. We now request you to give direction for execution of the lease before the deadline of 11/1/17. Lord, and mark to the Director of Mines, Government of Odisha at the bottom of the page. And this is exactly what the screening committee said. If my lords could just note at serial number 15 of the date sheet. Page 3, serial number 15, which I just placed for my lord's kind consideration. My lord has that?
Yes.
Screening committee constituted by the state in its meeting recommended the grant order for the mining lease may be issued in favor of the petitioner subject to payment of NPV. 26/12/2017, minutes of the screening committee placed before the interdepartmental committee, which observed the petitioner be asked to submit compliances in terms of so and so of the letter of intent and whether other conditionalities had been fulfilled. And the next is, your lordship saw at 17, NPV paid. So, my lord, he wanted us to pay NPV, done. There was no impediment on, in my respectful submission, for execution of the mining lease, which I have called upon him. And it is this failure, which is why we filed this writ, seeking the direction from the court. There is nothing more in my respectful submission which had to be done at my end. And which is why I say, my lord, if my lords could just for a minute come back to page 45 of the paper book.
Page 45.
45,
of-
the grant order again, my lord, of the writ petition paper book.
Yes.
I can confirm.
You have read para
Yeah,
2.
I'm just closing the loop only exactly in a minute. 1772 is the approval of the central government, right, my lord? This had two parts. I have now showed my lord the EC and the FC. So clause 2 is done. And clause 3, I've shown the entire sequence of events. So this is what I respectfully submit, crystallized into, my lord, a settled right which I had. And the Supreme Court, as far back as 1966 in Gujarat 40 says, grant order gives you the right. Execution of the lease deed is a ministerial act, it's a formality which the High Courts have also recently followed. That is my first line submission, all done and dusted, if I may put it, in my respectful submission. Now, my lord, kindly come back to the date sheet.
Yes.
Serial number 7. My lord, in January 2015, the MMDR Act was amended. In that, my lord, this saving provision, which I'm just going to put, 10A came. It brought in transparency. It changed the regime to an auction regime, but saved, words used there, certain category of cases. And in my respectful submission, I fall in that third category, which I'm going to show.
What is that saving clause?
Yes, if my lord would kindly have
You annex that amendment.
MMDR Act. The Bear Act. Not the MMDR Act, the Bear Act.
Yes.
My lord has the Bear Act.
Yes.
Master, sir. Yes, yes.
Yes. May I, my lord?
Yes, yes.
10A, rights of existing concession holders and applicants. All applications received prior
No,
to the
so
date
it
of
will not do
commencement.
this big. This is a 2014 edition. We need a 2015
The
edition.
new one is here.
Up to
And
us.
my lord, can I just make one humble request? When you have the Bear Act, I have also given a compilation of judgment. My lord should just have that bhushan. It just sets it out very clear and easy. So if I may just request my lords to kindly have that, I'll be very grateful.
We have to go up and down.
Courtmaster, the book which you have, please hand over this one. Yeah.
All right. Just refer from the.
So we have that book.
Please.
Yes.
Now we have that.
And your compilation.
You are referring to 10A.
Yes, ma'am. 10 capital A.
Yes.
May I, my lord, with my lord's permission? Rights of existing concession holders and applicants. All applications received prior to the date of commencement of the MMDR Act shall become ineligible. Right, my lord? So 10A made prior applications ineligible. Without prejudice to the following subsection, following shall remain eligible on and from the date of commencement of the MMDR Act. This is 10A to small b, A and B. Our case is in C. If my lord could kindly have C. My lord has C on where the central government has communicated previous approval as required under subsection 1 of section 5 for grant of a mining lease, i.e. page 45, 17 July 2002, which I placed for my lord's kind consideration.
Yes.
Or if a letter of intent by whatever name called has been issued by the state government to grant a mining lease before the commencement of the MMDR Act, the mining lease shall be granted subject to fulfillment of conditions of the previous approval or of the letter of intent within a period of 2 years from the date of commencement of the Act. Just park this, my lord, for 1 minute. If my lords could just have the case law compilation for a minute.
Physical copies also.
Physical copy has been given.
Can he imagine?
There is
H.
compilation of the judgment. Oh, it is there.
But please have page 15 of this compilation.
Page 50.
Yes.
You are referring para 16.
Just before 16, just to give my lords context.
Page 15 is a
Yes, page
meet-
15. Yes, madam. Page 15.
1-5.
Yes,
Okay.
madam.
1-5.
Para 19.
Okay.
That refers to the Amendment Act 2015. Just
Yes.
so that my lord knows that I'm showing exactly that which is relevant for today. Then, my lord, in para 20, it refers to the various amended sections, and it also has 10 capital A.
Hmm.
If my lord will just circle 10 capital A at para 20 of the judgment, it notes
Yeah.
all the various sections, my lord, which have been amended, right? Now, please turn over to page 16.
1-6.
Yes, my lord, para 22.
Yes.
Newly inserted provisions of the Amended Act 2015 are to be examined and interpreted, keeping in view the method of allocation of mineral resources through auctioning, which has been introduced by the Amendment Act 2015. Amended Section 11 now makes it clear that the mining leases are to be granted by auction. It is for this reason that subsection 1 of Section 10 capital A mandates that all applications received prior to 12/115 shall become ineligible. Right, my lord? Now comes my case. Notwithstanding subsection 2 thereof carves out exceptions by saving certain categories of applications filed before the amended act came into operation, i.e. my case. 3 kinds of applications are saved. My lord, your lordship would take it, I started, there are three categories. My lord, this para 22.1 has those. With my lord's kind permission, I will come straight to 22.3. That is the third category. So we are eligible and saved. Third category is the category of applicants where the central government has already communicated previous approval under section 5(1) of the Act for grant of a mining lease, or the state had issued a letter to grant a mining lease before coming into force of the Amended Act 2015. Here again, but kindly note, this is the raison d'etre is that certain right had accrued to these applications, which is the expression I had used in my opening submission, in as much as all the necessary procedures and formalities were complied with under the unamended provisions, and only formal lease deed remains to be executed. It would thus be seen in all the 3 cases, some kind of right in law came to be vested in these categories of cases, which led Parliament to make such a provision, saving those rights, and understandably so. So, my lord, I have a prior accrued vested right flowing from the central government approval, and 10A2C saves certain categories. I fall in category 3 because I have a central government prior grant order. This is the right which I have, which is why it said, my lord, in 22.3, only a formal lease remains to be executed, which is the corresponding obligation on the state government to have executed that lease deed, and the failure to discharge that obligation is the subject matter of writ, for which we are seeking that direction. So, my lord, this exact situation is contemplated by the statute. It categorically saves certain types of cases. Applicants, such as myself, came up for judicial consideration in the Supreme Court, and in 22.3 and 22.4, the two paras which I placed for my lord's consideration, at page 16, they say there's a vested accrued right.
Yes.
That's the intent of the legislature, which is why they created an exception. And I fall in this category, and therefore, my lord, the only act which had to be done by them was a formal lease deed remains to be executed, which they have failed to do. I just
That's
wanted to place this so that my lords could correlate, my lord, the amendment with this.
So that's what I think.
Sorry, my lord.
I think no more submission is there. So you have-
It's always my lord's pleasure, my lord. So,
all right, I think you have done it. Yes, Learned General.
my
Lord,
lord,
may it please the Lord.
just for completeness only, the case of Ultratech Cement in the compilation went up before the Rajasthan High Court single judge division bench. Another case went to Guwahati High Court, and my lord, directions have been given to execute a mining lease deed. If my lords could just give me the indulgence of making a note of that in this compilation. If my lord could kindly come to the index first.
Compilation.
My lord has the index of the compilation.
You give the serial number of the index.
My lord, I have placed the first one, Bhushan Power and Steel, which I just placed for my lord's.
That you have placed.
Yes, that I've already placed.
Yes.
So if just for my lord's with a special category which is protected is the ratio of that judgment.
But
Now
that you have
have
given the relevant paragraphs also. This is
all given, my lord. Remember 22.4, which I just placed.
why
at
this
page-
Karnataka High Court decision.
Yes, next one. I'm just showing. Now, my lord, kindly turn to page 22 for a minute of the Karnataka High Court decision, my lord. My lord, page 22. At 24. This will be of great assistance to my lords if my lords could kindly have it.
Suppose para 17 at page. Page 20.
My lords have
24.
page 22, para 17. Answer is at 24. I want to show the issue, which will be of great assistance to this court. May I? Issue 1, para 17. Where the prior approval granted by the first respondent in favor of the petitioner under section 5(1) was saved by section 10A(2)(c) of the Act. Right, my lord?
You are referring to para 17.
Para 17, issue 1 at page 22.
Right.
Whether the prior approval granted by the first respondent in favor of the petitioner under 5(1) was saved by 10A(2)(c. With respect, same issue is what I am placing for my lord's consideration, expressly answered at page 24.
Yes.
Para 22 and 23. It is clear that the apex court has categorically held that if the prior approval under 5(1) of the Act has been granted and communicated, then the right of the applicant to obtain a lease stands saved, and execution of a lease in favor of such an applicant was only a formality. And 23 grants the relief, my lord, if my lord sees the last few lines. The petitioner became entitled to obtain a lease of land in his favor from the state. Issue 1 answered accordingly. So, my lord, exactly what I'm seeking for my lord's kind consideration.
Yes.
Now, my lord, please have
Page 20, para 45.
page 26, para 45.
In the written. Elections.
All right.
Writ is allowed, and the second respondent is directed to execute mining lease in favor of the petitioner after complying with the procedure and formalities, etc. Right, my lord? Relief granted. Now, my lords will note two other judgments. Now, my lord, page, may I proceed?
Page.
Now, Guwahati High Court, I'm just
Huh.
giving the relevant, your lordship, just note it on the index. It's serial number 3, page 35, para 39 and 40. Exact direction. Instant writ petition is allowed, directing the respondent to grant lease and execute the same immediately within 45 days. You know, page 35, para 39 and 40.
All right.
So, my lord, they say fit case for mandamus, do within a time bound period. And my lord may skip the and come to serial number 8 of the index. Ultra Tech, my lord. Page 95 and 96. Okay.
Yes.
Does my lord have 97, my lord? Para 43. My lord has 97.
Yes.
So these last two paras exactly fit into the submission I've placed for my lord's kind consideration. The newly inserted 10A is in two parts. The first part in subsection 1 provides that all applications received prior to the date of commencement shall become ineligible. Thus, by operation of law, it is vividly clear that applications received prior to the appointed date stood rejected, rendered automatically ineligible. The second part of 10A, as contained in subsection 2, carves out exception to subsection 1. Categories A, B, and C of 10A2 exhaustively enumerated therein save certain applications from being rendered ineligible by the operation of law. And if my lord kindly comes to 98, he expressly in the middle of the page says that these applications such as mine stands excluded, consequences would not follow, and the applications do not become ineligible. Expressly, my lord. At page 98, about 8 lines from the bottom. Thus, by operation of law, application would not become ineligible. So, consistent, my lord, from Bhushan, various judgments of the High Court have granted a mandamus directing execution of the lease, saying if you're a 10A2C case, falls in the third category, you had a right which had vested, it is saved, it is not, my lord, destroyed, and you are not ineligible in any form. So this also, with great respect, is of no aid to them.
Is a part of paragraph 44?
No, I was reading 43, which continues on to page 98. It's a very long para.
Okay.
If my lord just comes to my lord 98, about 8 lines from the top.
The application remains pending until it is rejected. This part?
No, we are on. No, my lord. We are on.
You're reading from the above of the para 44.
Yes, right. Yes. No, my lord. I'm reading on the top of 98. If my lord can kindly go to the
Okay.
top of page 98, please come to 6 lines from the top. However, second part of clause C of 10A2 saves application where a letter of intent has been issued by the state government prior to commencement of the act, that is the amended act. Thus, in a case where letter of intent has been issued by the government to grant a mining lease prior to commencement of the MMDR Act, operations of 10A1 stands excluded and the consequences provided therein would not follow. Thus, by operation of law, the application would not become ineligible. So, my lord, it remains intact. If I may use the word, it is preserved. Neither do they fall or have a demise, nor do they lapse. None of the provisions which they are going to rely on and place for my lord's kind consideration in the light of the express parliamentary intent of saving certain applications where rights had accrued, which had reached fruition, completion, minus execution of the formal mining lease has been saved by operation of law.
Yes.
So, my lord, these judgments in my humble and most respectful submission, my lord, would assist my lords because the relief that I've sought for is similar to Karnataka, Rajasthan, Guwahati. In all cases I've shown, they have asked. That is, as my lord rightly put to me, is the only prayer and relief which I'm seeking in this petition today, which is the direction to them to forthwith in a time-bound manner execute a mining lease
All
order
right.
in view of the settled position
Okay,
in law.
thank
My
you.
lord, there may be some other aspect which I will rejoin to, but for the present, my lord, I'm very grateful.
Let me please your lordships. This act is of 1960 minutes. And in course of time, your lordships have held certain things, my lords. A, the state is the owner of the minerals. There is no doubt about it.
Yes.
B, my lords, there is a procedure for grant. And the procedure is that a lessee applies. The state government recommends. The government of India approves. Terms and conditions are issued. The applicant accepts and it culminates in a lease deed. These are these various steps, my lords, under the old act. In 2015, the Parliament amended this act. What it said is, my lords, that now all grants will be made by auction. These are natural resources. The state is the custodian. The state must get the best value for the mines and minerals. It said all pending applications go. 3 exceptions were made. Exception 1, my lords, that if you have prospected this area, that means you have invested to find out where the mineral is, and that prospecting has been carried out satisfactorily, you will have a preferential right. Second, if you have an approval, then you will also be considered for grant. So primarily we are concerned with these provisions. Now 10A2C also said, that this has to be done within 2 years. In 2021, the Act went further amendment. Now, this new amendment said that all that is not done till now will be deemed to have lapsed and shall be put to auction.
Why are you referring to this provision?
I'm just telling your lordship
Because
what
there
is
is a
the scheme.
litigation.
I will straight away answer your lordship.
Yes.
The question before your lordships is that in 2005, there was an approval and therefore under 10A2C, they have a right for grant. Let's put it at the highest.
Yes.
The 2 questions will fall for your lordship's consideration. A, if the approval as set out under 5.1 is not in consonance with my recommendation, is the state government bound by it? Number 1. And if the state was bound by it, my lords, somebody is now coming in 2021 saying that I want to enforce something that had happened in 2015, knowing fully well that that was not a approval to be acted upon. And I will tell you, lordships, why. After the approval came, I gave him the terms and conditions, which specifically said that there will be a prior approval under 27(3). He accepted that. He had the choice of saying that, look here, the approval under 5.1 does not talk about a 27(3), so I am not going to agree to that. He did not do that. Kindly appreciate me, Lord. Today, what he is saying is contrary to what he had accepted. The submission to your lordship is this. If your lordship sees a few documents, my lords, that why I was insisting on a 27(3) approval, that is the key to this issue. If your lordships agree with me that that 5-1 approval was not a 5-1 approval which the state was wanting. By one,
You are showing page
page 231,
2, 3.
annexure D by 1, a meeting held on 26th of December. Where did this meeting?
Yes,
No, just give me half a second.
yes.
And if my lords are kindly turn to page 239 before I come back to 231. My lords have it, my lords.
Yes.
Kindly see who were present in this meeting. The Principal Secretary Steel and Mines, Principal Secretary Forest and Environment, Additional Secretary Revenue, Principal Secretary Law, Member Secretary State Pollution Control Board, and even the Director of Mines.
Yes.
The one your lordship saw. Now kindly see my lord page 231. My lords have it, my lords.
Yes.
Kindly see Roman 1. ML application filed by Odisha Sponge Iron, present petitioner. The screening committee has recommended that in view of the compliances made by so and taking into consideration that the applicant has established an industry inside the state, thereby contributing to the growth and economy of the state, state government may issue a grant order in favor of an applicant under so, subject to verification of so. The interdepartmental committee noted that the applicant has not submitted compliance to the document conditions in Roman 12 to Roman 17 of the letter of intent, terms and conditions issued with a letter number so, though it has accepted the said terms and conditions. What had fallen from your lordships?
Yes.
The conditions at clause 12 to 17 of the LOI relate to investment of the company within a definite time period specified therein. It is also noted that the sponge iron plant of the company has been closed since 2012. Hence, the committee did not agree to the recommendations of the screening committee. The interdepartmental committee therefore recommended, Lord, industry was closed from 2012 to 2016. The interdepartmental committee therefore recommended that the applicant be asked to submit full compliances to the terms and conditions of the letter of intent, more specifically clauses 12 to 17 thereof. The applicant may also be directed. So therefore, that directors meeting has now been overturned by the director himself in another larger committee, in the meeting of the secretaries. Now I'll tell your lordships, my lords, what is the background to this case and why is the state was insisting on a 27-3 recommendation. Your lordship may see, my lords. Let us first look at what he applied for. Because why this 27-3 came up, there is a background to it. And if my lords kindly turns to page 334 of the brief, my lords. It is an additional affidavit filed by us on 18th of April 2023, page 334. My lords have it, my lords.
Just a minute. You
Kindly see, for my to be submitted an applicant, your lordship may see 29-10-91 is the application. If my lords kindly turns over to page 336, my lords.
336.
336. This is his form because that is the base of his whole case. Now, if your lordship sees Roman 6, minerals which the applicant intends to mine. Your lordships have it, my lords?
I don't know. All right.
I know. Now let us see the next one. Period for which mining lease required 20 years. That was the scheme of the act. Now kindly see, my lords, page 340. My lords have it, my lords?
Yes.
Kindly see Roman 19. Your lordships have it, my lords?
Manner in which?
Manner in which mineral raise is to be utilized. If for captive use, the location of the plant and industry. My lords have it, milords.
Yes, yes.
Kindly see, milord, this is very critical. Manner in which the mineral raise is to be utilized, if for captive use, the location of the plant. So what they write? Sponge iron plant at Palaspan. So they have a plant. Now look at the next column. For sale or indigenous consumption, because if you want, do you want to sell it? The answer is to be consumed as a raw material in the sponge iron manufacturing plant. Now what is the next one? If for exports, not applicable. Kindly come down, milords. Roman, just English C. If it is used to be used within the country, indicate the industry, sponge iron manufacturing plant. So therefore, this applicant said that please give me a captive lease.
Yes.
And therefore, my lord, the condition of a captive clause became imperative for the purpose of granting him the lease, so that over the next 50 years, he does not trade in iron ore. He does not export iron ore. Now look at my recommendation. Your lordship saw the approval. The approval has to be read along with the recommendation. Look at my recommendation, Lord, page 42.
4-2.
42, 4-2 of the writ petition. This is dated 2nd of February 2000. Your lordship knows, my lord, I recommend they approve. It has to be always in the context of the recommendation, because these are interdepartmental statutory correspondences being made. My lord, look at 2nd February, my lord. This is State of Orissa writing. Kindly see, my lord, this second paragraph. This is very important. Let me read the whole one. I am directed to say that in pursuance of notification of 23/8/91 of the state government, 43 numbers of ML and PL application, mining lease and prospecting license, were filed simultaneously on 29/10/91, Odisha Sponge, and 42 others for iron and manganese ore in village so and so, applied for so and so. Lordship may leave all that. After scrutiny of all the 43 numbers of applications, 29 number of applications were found either deficit in furnishing or required documents or applied for overlapped areas in favor of so and so. Your lordship may skip all that. Kindly turn to, my lord, page 43. Out of the said 43 number of simultaneous applications, 14 applications were found suitable for consideration for grant of PL and ML. So there were 14 persons whose applications were found to be suitable for grant. So now why I pick up this gentleman? Kindly see the next line. Messrs. Orissa Sponge Iron Limited have applied for grant of a mining lease for iron ore over so and so in village so and so, district so and so, to meet the captive requirement. Kindly underline this, my lord.
Yes, yes.
To meet the captive requirement, the applicant says, I will not sell, I will not export, I will use everything here. For the captive requirement of their existing sponge iron plant at Palaspanga, Keonjhar district, and kindly note, my lord, and proposed sponge iron and pig iron hot metal plant at Bamra. So why I am recommending you? You have a plant already. You are not going to set up, you are in the process of setting up another plant in the district of Sambalpur. The sponge iron plant of Palaspanga with the installed capacity of so and so, under expansion production capacity of additional 3. Your lordship may note below, no addition have ever happened till now. That 1 lakh remains to be 1 lakh. Expansion capacity of so and so requires 8 lakh million ton of iron ore per annum. So also doesn't end here. So also the proposed sponge iron and pig iron hot metal plant at Bamda with the production capacity of so and so in the phase will require 14 lakh metric ton. My lord, we are now in 2000. Today we are in 2024, 23. No Bamra. Nothing has happened. But thus there is a total requirement of 2.2 million tons of iron ore for their own consumption per annum. there is an estimated reserve of 108.77 million tons of iron ore in the applied for area, which will take a minimum period of 50 years to run the plant for consumption at the rate of 2.2 million tons per annum. So what were the reason why I recommended, my lords? There were admittedly 14 applicants. Here is somebody who is saying, I have a plant. I am expanding it from 1 million to 3 million. I am putting up another plant at Bamra. All this taken together will have a requirement of X amount of 2.2 million per year. And therefore, I am recommending. Well, let me read further. The company has got itself a qualified geologist, and all that. But next paragraph is very important. Taking into consideration. So what, my lord, whatever is stated in para 2, taking into consideration all the factors narrated above, the state government have decided to grant mining lease of iron ore over an area of so and so in village so and so, district so and so for a period of 20 years. It is therefore requested that approval of the Government of India may please be obtained under section 5.2, read with 8.1 of the MMDR Act for grant of mining lease for 459. So what am I saying? Here is the captive applicant. These are his assurances. I don't want to consider other 14 because they will trade in iron ore as opposed to this gentleman who will only put it in his plant. He has promised me 2 plants. One will be expanded, the other will be put up. And therefore, I am selecting you over the other 13. Now today, Bamra is out and the application is for captive. I am recommending for captive. Now the Government of India, my lords, gives an approval at page 45. Your lordships have already seen it.
We have already seen
Your lordships have
yes.
seen it. It did not come with a captive clause. The very reason why I did not look at the other 13 and looked at the present petitioner was that it said I am only captive and nothing else. And once I grant a lease, your lordship saw, it is for 50 years. So for 50 years, if I am granting him a lease, I have to be certain as to what he is going to use that for. Now, why 27.3, my lords? 27.1 and 27.2 are general conditions.
Learned Advocate General, there is a issues is.
Yes, my lords.
Because we do not find any communication asking any assurance from the petitioner
My lord.
that this has been observed and this is the reason, this is the grounds, we may not grant you and we may be review. You have already reviewed. He was supplied the copy of the minors.
Correct.
Money was transferred from his bank to on your account.
Not to my account. Not to my account.
NPV.
Nothing. Forest Department. Government of India Forest.
All
That
right.
money he will get back. I have nothing to do with that.
No, it's all right. Get back
Yes.
is one thing.
Yes.
He has altered his position
Because
substantially.
my point is this.
Yes.
Has he altered his position? On page 45, your lordship see,
Yes.
he didn't alter his page because of 45. Kindly look at what is 46. Because we are looking at a payment net 10 years after. Let us look at 46. 46 is the contemporaneous document of that time.
Yes.
So let us see, my lord, in 46,
Look at
what did I tell him?
46 again? Yes.
Let us see whether in 46 I had told him that I am going to grant you a lease under 5.1, under the approval at 5.1. If one could have said in 46 that look, this MOU is after the approval of Government of India. Am I clear, my lord?
Yes.
Now that approval does not have a 5.1 condition. That doesn't have a captive condition. Why did you sign the MOU? My lord? I asked myself this question. You could have said, sorry, Government of India has said not issued any captive clause. You wanted a permission.
Till today, Mr. Join has not argued a single lie that
Yes.
I will not comply with that captive condition.
No, the time is over. Kindly see, my lords. The time is over. What you did not do from 2000
Yes.
to 2023, today if you say I will do it, we have to wait for another 20 years. I don't know. This is one point.
No, we are failing to understand your point.
My lord, my point is this.
Because
Well,
the
nothing
entire
he has
process
done.
was stuck in your end. He has complied whatever you asked for.
No. Kindly
Show us that he has not complied.
My lord, let me tell you, lordship, what he has not complied.
Yes.
Has he done Bamra, madam? Has he done Bamra? Bamra was the bigger plant between the two.
Yes.
Is there an affidavit before your lordships that your recommendation was based upon Bamra and your recommendation was based upon one becoming 2 million? Has that happened? I ask myself this question, my lords. Does your lordships find any averment that the recommendation which was made for these two plants has already been completed? Let us see. That may not be the final answer, but it is not there. So, very basis of my recommendation that I am giving you this on your assurance of A and B with great respect are absent even today after 23 years. But today Mr. Jain can say, I will do it. Maybe next 23 years, I don't know. And there was a cutoff date in the MOU by which time you should have done it. Let's understand like this. Why this writ petition was filed? But I ask myself the question that you are trying to enforce something which happened in 2000 in the year 2017. After 17 years, why didn't you come and tell the court within a reasonable time that I have complied with everything?
Because the minutes that was first prepared, it was in 2016.
No. Kindly see, my lord. By 2016 Act has been amended. By the 2016 Act has been amended. What followed after my approval was a very important document on 2nd February 2000. Kindly note, my lord.
No, that you have taken note of. 2nd
Yes.
February.
I'm sorry. Kindly look at the MOU, my lord.
Annexure 1.
Look at the MOU. My lord,
Yes.
the MOU, what the MOU does is so interesting, my lords. It in a way, my lord, it nullifies the approval under 5.1. The state government and the lessee both agree. This is very critical. The state government and the lessee both understand that this 5.1 approval without a captive clause cannot be implemented. And let me tell you, lordships, how. Kindly see, my lords, the MOU. It starts at page 46. Lordship may see, my lords, page 47. And what is interesting, your lordships will know, this is post 5.1 approval, very critical. Kindly see page 47, foot of the page, my lords.
Yes.
Iron ore, the state government have already recommended and the central government have approved the proposal for grant of specific mining lease in favor of so and so. The grant of mining lease will be subject to the following conditions. Kindly turn over the page, my lords.
Yes.
Now kindly see, my lord, that Palaspanga, Roman 2, page 48, my lords. Top of the page, there is a table. My lordships have it. The company shall undertake expansion of the existing sponge iron plant at Palaspanga and proposed projects with the time schedule indicated below. Kindly see, my lords, what are the time schedules? Now look at Palaspanga is the first part, Bamra is the second part. Bamra has not been done till today. And we are entering into MOU in the year, my lords, 2004. And look at the top half. Even Palaspanga, my lords, this is not 4 lakhs. Now your lordship may see Roman 4, my lords. Your lordship may see the targets at page 48 here. 4 lakh tons, my lord, sponge iron plant. Your lordships have it.
Page?
Page 48. My lords have page 48, my lords.
40.
48.
48. Yes.
48.
48. Yes.
Yes, kindly speak sponge. Existing 1 lakh. In the table.
Yes.
2004-5. 1 lakh 50. My lordships have it, my lords. And now 4 lakhs. Hot metal. Kindly go a little down, my lords. Hot metal. 0. By 8-9. 2 lakh 10. Look, total 2 lakh 10. Now let us go down. Hot metal power plant megawatt. Today it is 8. And it is now 42. And total 54. Where are these? Where are these? And if your lordship sees now, the next one, Bamra, everything is not there. My lord, we are talking of special minerals of the state. And I have preferred you over 13 applicants because you promised all this. And all that had to be done by 2009 and 10. And you have agreed to this. My lord, state largesse.
Yes.
Kindly turn over the page, my lords. Roman 5, the assignment is subject to close monitoring by the state government. Your lordships have it, top of page 49.
Yes.
The assignment is subject to close monitoring by the state government through yearly reviews. During any of the review, it is seen that the portion of the stipulated capacity is not likely to materialize within the time frame. It will be lawful for the state government, after giving the compensation opportunity heard, to make and direct order directing a portion of the deposit expected to contain. So I can also reduce the quantum of deposit if you don't do all this. Am I clear, my lords? I have given you X amount of mineral based on Y amount of assurance. If you don't do it, I will decrease it.
But you have not decreased it.
He has done nothing. Where have I given him? He has done nothing.
He has denied it.
Seeing in this
That is
table,
the
nothing
issue.
has been done. But nothing has been done. Kindly look at the next paragraph. The assignment is subject to further condition. The mineral exploited shall be exclusively utilized for captive of their existing plat at Palaspanga and Keonjhar and proposed steel plant at Bamra, my lord. My lord, without Bamra, can somebody come to a writ court and seek equitable relief? I ask myself the question. You have not expanded. You didn't set up Bamra at all.
All right.
And you come for equitable relief to a writ court. But kindly read further. My lord, power plant. Nothing. At the foot of the page. Now kindly turn over the page, my lords. 27.3.
Yes.
Here also letter of acceptance. Where is that? There is the next one. Your lordships have this MOU, my lords. This MOU was periodically extended. Kindly note, my lord, all this is happening after 5-1. My lord, kindly note, my lord, all this is happening after the approval. So it is not as if something has been crystallized. The argument is 5-1, everything is over. Now under 10A2C grant, the answer is sorry. 5-1, even after 5-1, you are still signing MOUs with the government. Because the government is crystallizing a right for 50 years. And today we are saying there is one 10A2C have a right. What right you have got? No right till you have a lease deed. Kindly see, my lords. Now, my lord, next page, if your lordships kindly see, my lords. Let us now see 27/9/2004, page 52. Your lordships have seen the MOU? Nothing. Now let us come to the terms and conditions of the lease on 27/9/2004. Your lordships have seen this document. I will only see, my lords, show your lordships page 55.
Yes.
Page 55, my lords. Your lordships have it.
Para 2.
I am grateful. My lord, it's page 52. It starts at page 52, my lords. My lordships have page 52, my lords.
Yes.
The lease will be subject to the general terms and conditions laid out in the model form and to the following conditions. My lords may kindly see, my lords, Roman 12 at the foot of page 53.
Yes.
The assignment is subject to the company shall undertake expansion of sponge iron plant at Palaspanga and the proposed Bamra projects within the time schedule indicated. My lord, I pause here for a moment, my lord. We are in 2004. My lord, today when we look back, the state government took the right decision in my humble submission, my lord, in not granting the lease. They could not have envisaged in 2004 that till 2023 not would happen. My lord, who comes before your lordships, my lord? Somebody comes before a lordship bona fide.
Clauses that you are referring to, that is also covered by the para 2.
I'm grateful.
And the central government says this is not within your domain to decide these conditions.
No, my lord, I'll tell you, I'll answer your lordships. The central government thereafter, I will show you lordships. Thereafter correspondences happened, it's not ended there. Thereafter, at the highest level, there was a discussion and they have asked me to give me what is the status of the project. So it is not as if the correspondence between the state and center closed there. It did not. My submission to your lordship is this.
No, this is, come to the question the first you raised.
Yes.
Regarding the what will happen if
Yes, my
the conditions covered by the Rule 27
Yes, my lord.
is denied by the central government, how the impact will be taken on the other conditions.
Let me straight away answer your lordship.
Let us continue tomorrow. It's not be complete today.
My lord, tomorrow is that other matter is also there after lunch.
No, that is what.
So if you are,
Because now these are certain matters are there. It's very urgent in nature. We have giving this.
my lord, I am completely in your lordship's hands.
Mr. Join, when will be available next time?
My lord, next Monday, Tuesday, I'm not there. Wednesday is already. But Wednesday we won't have this. I am going up. No, next Wednesday we have that other one. The 2 o'clock matter. GMR. My lord, let us fix a date after we complete GMR. Because after we complete the 2 o'clock matters, your lordship,
The 2 o'clock matter. 2
after
o'clock
that,
matter
any
is-
date after that.
That is, I think, 3rd and 4th last.
3rd and 4th or 2nd is the last the date.
Any date after that. Your lordship, no,
Actually,
my lord, I am
go to
also.
go after this and.
Because, my lord, I am
8th of
telling you, lordship,
August,
I will
find
take
out
another,
date
I will.
After 8th of August. 10th is all right, Mr. Jain.
Fair enough.
But can I just make one request? Your lordship may tentatively indicate 10th. In case of something, I'll just speak with my learned friend. Will inform the court master.
No. Give a firm date because we
just-
have already heard.
No,
substan-
shortly. I'm just saying, without troubling my lords, tentatively 10th. But in case some change,
Not right now. You will communicate
yes,
later.
in the next 15.
Communicate. You talk to.
Yes, yes.
And
My
we'll-
lord, I will mention before your lordship. If he calls me for anything, I'll let you
Just
lordship.
come to an agreed date because we don't like to go.
No, my lord, I'm okay with it. 10th is okay for the time. Let 10th be there.
No. So when the date is, we are leaving it to you. You just communicate us,
Yes, sir,
talking
we'll
to each other.
We
then
will-
put
we
the
will do
date
that.
in the order.
Yes.
During lunch time, you talk to each
Fair
other.
enough.
Right?
Grateful to your lordship.
Heard substantially. But the hearing
Well,
could not.
pleadings complete. For Union of India, file the counter for OP number 3. The mining is a main contesting party. They have implemented the Ministry of Law. They don't have any rules. That's why you not
So,
file.
all right.
this. Yes.
Any action of yours is also not under challenge.
But interim orders to continue.
Just heard substantially, but the hearing could not be concluded.
Your lordship may say 2 p.m. minutes.
Let the matter be listed on, give the date at 2 p.m. for continuation of hearing. Just give the list, the name of the council will reflect in the order.
We will give the list of councils.
Call the item number 44 first.
Deeply grateful.
74. Keep these things.
Obligement.
Grateful.
Thank you.
Along with me, Mr. Bhokta is appearing.
Please
His
give
name.
it. Give.
It's
As
just-
long as
just-
Mr. Paddy is willing to share the fees.
No, you are drawing closer to you. That is a danger signal for Mr. Jain. Okay. He should have been the
That's it.
passive participant in
I
this
know.
matter, not much active. Okay. Let us see.
Grateful minutes.
Item 74.
So you have okay, it will come on 17.
6, 7, 8 also same.
May I give them all the numbers, my lord? All the matters, I can give the numbers. 45 matters are there
Today's list.
in today's list.
So we have listed today's list.
Yes,
yeah,
yes.
17. No,
Those
the
numbers-
numbers will be this is a common, all the numbers will be in the order.
Yes,
This
ma'am.
is sort of a common order.
Yes,
That I am serving. That I am.
That will do.
Yes, ma'am.
This, you need a copy?
No. I have,
Alright, you keep the, cause list is there.
Let them
Okay.
serve a copy, man. The counter, they are adopting, let them serve copy.
I am not reflecting, Mr. Kuntia, just supply the copy of the counter affidavit.
I'm
You
just
have not
supplying him
supplied.
his-
Yes, it is exchange between yourself.
Your Lordship said that pleadings are exchanged.
Uh,
You also record that the counter has been served.
all right.
How can I wait?
It will not record. Next week there will be another issue. We are not recording. You are
Your Lordship,
satisfied.
fix up a date.
Yes, this is the rule.
Keep a receipt.
All right.
Your Lordship is fixing it to
17th August.
Oh, another two matters, item number 19 and 20, batch matters. Batch matters.
19, you have already passed the order.
Your Lordship passed it.
That is 17, it is a 19, WA.
No, 19 is some different matters. Mr. Rao and myself were there. That is the board is the petitioner, the appellant.
No, 19 is the writ petitions.
No, 19 is the writ appeal.
A writ appeal. And you are mentioning? What you are saying the 19? What is the matter they are making submission? Which one?
19 is the batch matter.
And what is the other matter? Oh, this is the only batch matter? And what matter you are mentioning? Other matter?
This 19 is the writ appeal, a batch of
this
writ
is
appeal.
writ appeal. That is why.
So there are some defects in those writ appeals who may be permitted to remove those defects. You'll also fix up a date so that
Already writ appeal, we have fixed the date on 17.
no, these so far the writ petition are concerned, that is different matters.
Where, which number?
That is right 6, 7, 8, 9, 14,
Already
15,
take
16, 17,
give a,
item 38, 39, 40, 41, 42, 43, 44, 45, 46.
In the writ appeals, the defects as identified, this batch by the registry shall be removed by this time. Oh, this is, you just give a list of this number.
Yes, 19, 20 are different. That is writ appeal. These are all writ petitions. Challenging varies. I'm giving, Mr. Khuntia is giving the numbers, all the numbers.
All right. This will be fixing on 21st of August.
Yes.
21st of August. The list, no, not 19. 19 is on 17. Don't
Yes.
confuse us.
19, 20, 17. Yes. Yes.
Yes.
21st of August.
The Khuntia, please
And,
give a list so that
Mr.
it can be
Doctor,
listed
you
together.
also give
I'm
the
together,
name of the
together.
councils.
Similar matter, okay?
21 along with the analogous matters.
Entry model.
After getting the list, type all the numbers together and then they give this order. Okay.
You will give the list.
20 is also same.
Yes, 19, 20 same. In 19, I have filed the
20
appearance
also
memo. Mr.
separately
Rao has
passed, huh?
filed the
The
appearance
the
memo.
order passed in 19, just 20 will pass that order. And Mr. Kuntia, give the list.
Yes,
It will
I'm
come on 21st of August.
just now I'm giving.
In item 19 and 20, that is interim order. Let that interim order to
Interim order, if any is passed earlier, shall continue. All right.
Only 19, 20 are related, no other matters.
no other matters.
Okay. The 20 the one se jo 19 जब ग्रहण 20 को सजना. हाँ.
Challenging the common judgment.
Lordship, item 75. Lordship, item 75, your Lordship has personally appeared for this court, your Lordship petition.
Interim, just list the matter on 11th of August is all right. 11th of August, till then the interim order is
Pardon,
passed
Lord.
earlier shall continue.
Item press admission 3, item 3, your Lordship. Lordship, I pray take up tomorrow, your Lordship.
Why? What is the urgency?
It's urgency, your Lordship. I am for the caveator, Lordship. In this case, since 2017, my unit has been sealed by the BDA, Barampur Development Authority.
But you are sleeping.
My Lord,
You have filed a caveat only.
yes, your Lordship. In writ appeal, Lordship, the Honorable Single Judge passed dismissing the writ application, challenging that BDA filed this writ appeal, your Lordship. And on the plea of a pending of writ appeal, the
Day
authority.
after tomorrow, day after tomorrow, come day after tomorrow.
Day after tomorrow, holiday, your Lordship.
Oh, 20, day after tomorrow means next working day.
Yes, your Lordship. Third day.
Item
Oblige,
3.
oblige.
Item 3. Item 3. Item number 3.
Yes, your Lordship. Item 3.
Just day after tomorrow.
Oblige.
Item 64, a date may be kindly fixed. The counter has been filed. It's a PIL matter.
the another writ petition was tagged with it. Lordship may kindly fix a date. Item 64.
Date will be given. You just track give all the dates, huh? Ah.
My lord, item number 30, my lord, PIL matter. Let the date be fixed, my lord.
Date will be given.
Given. A short date may be given.
In the month of August, date will be given.
Oblige, my lord.
Yes.
Lordship, item 35, sub item 1, this is tagged with other matter. This is college matter. It is
21st of August.
it is listed for 17th August. That college GI virus matter.
This the writ appeals.
No, it is not writ
August.
No, my lord,
It
35.
is wrongly tagged.
And wrongly tagged. All
the day, 21st of August, you mentioned.
17th, all these matters are listed. 17th August.
Similar matters on 17th.
On 17th August.
Already on 17th, because today you cannot check up the record.
No, Lord.
17th
That's
you
what I'm
mentioned.
telling, let it come on 17th. Because
This will come.
I-
This will come.
because on that day I have to start. So,
35 is not related to this list. Just find out from it.
One matter has been wrongly linked and the connected matters are listed on 17th.
You please come on 17th. Let us
17th.
pass the order. Yes. He says he's part of that batch. Let us see. We're seeing the record, such order cannot be passed. Yes, come on 17th. You mentioned the matter. We'll look into this. Solve.